One of the biggest changes in immigration policy under the Trump administration that has snuck up on me, and in fact it's snuck up on many practitioners, has been the change with respect to the H-1B, or temporary specialty worker visas. These are visas that have a strict annual limit, and they are favored by businesses, especially high-tech businesses, so you would figure that there would be a high level of support for the H-1B visas within the Republican Party. Yet, Donald Trump has succeeded in turning the H-1Bs into a sort of pariah, a perceived danger to American workers. He's used that, as well as fairly recent cases of big-name companies abusing the H-1B visa category to further a bigger goal of his and of his far-right supporters. And this is the goal of cutting down on immigration in general, whether legal or otherwise. But H-1B visas is one area where the Biden administration may have the greatest power and indeed the greatest degree of effectiveness in reversing Trump's blatant anti-immigration agenda. And we'll talk about that in just a moment. My name is William Kovatch, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. The H-1B visas are for temporary specialty workers. These are workers in a job that require at least a bachelor's degree as an entry level. This is a visa that is favored among the tech industry, such as computer engineers and software developers. The visa is initially issued for up to 3 years, and it can be renewed for up to a total of 6 years. But there are strict annual limits on the number of visas, and that's 65,000. Now, there is an additional 20,000 H-1B visas that are set aside for the holders of advanced American degrees, a master's degree or higher. And there are certain trade agreements that have either allotments of H-1B visas set aside for them or something similar for that particular country. The visas are valid for the next fiscal year, which starts on October 1st, and you can apply as early as 6 months in advance. That means your application can be submitted as early as April 1st. When I started in the immigration field, legislation was in effect that temporarily raised the annual limit to over 100,000 visas, and it was rare for the annual quota to be met. But that legislation expired and it wasn't renewed, which was a little surprising at first because there was support, even within the Republican Party, for the H-1B visas. If the quota is met within the first week of April, USCIS will then hold a lottery, so not everyone who files on time may necessarily be guaranteed a visa. If the quota lasts beyond that first week, then the visa is available on a first-come, first-served basis. In recent years, the quota has often been used up in that first week of filing. Employers take on some very serious responsibilities by applying for an H-1B visa. They are not permitted to displace an American worker, and they can't undercut the salary of an American worker who is doing the same type of job. Employers have to agree to pay a prevailing wage, which is the wage offered to an American doing the same work. In fact, employers have to file an attestation agreeing to follow these conditions. They do so through the Department of Labor in a process that's called the Labor Condition Application, or the LCA. There's a whole computerized application with the Department of Labor. It involves a very detailed analysis of the job offered, what the duties are, and what the prevailing wage would be. An employer must have their LCA approved before they can apply for the visa itself with USCIS. And it can take a week for the LCA to get approved. It is not an easy automatic process. Plus, the H-1B is one of the most unique visas in the non-immigrant or temporary visa category. And that is, it is one of the few non-immigrant visas where you can have dual intent. If, for example, you apply for a visitor's visa, you cannot have the intent to move to the United States permanently. And if you do so anyway, you can face serious consequences. But with the H-1B visa, the applicants very typically do have the intent to eventually stay in the United States permanently. That's what it means to have dual intent. In fact, it's very common to be working on an immigrant visa at the same time that you are filing for an H-1B visa. And that is why the H-1B visa has become a target of the Trump administration and his anti-immigrant far-right supporters. There was a very conscious decision made by the Republican Party after the 2012 election, and that was to throw their lot in with uneducated white voters. This is a demographic that is quickly becoming more and more of a minority. White voters in general are expected to lose majority status in the United States by about 2048. The far right has chosen to try to cling to their power by delaying that 2048 predicted date and delaying the expansion of the non-white population in the United States. A good number of the H-1B visa recipients are either from India or China, so they are a clear target for Trump's xenophobic supporters. Now, it is true that in the last 5 years, there have been high-profile cases of large American corporations who have been alleged to be abusing the H-1B program and hiring foreign workers specifically to cut their costly American workforce. The allegations have included big American companies such as Disney, Walmart, Infosys. There are penalties in the law for abusing the H-1B system, including cutting an employer off from hiring foreign workers through the H-1B program. Nonetheless, this is played right into the hands of Donald Trump and his ilk politically, as it gave them the cover that they needed to attack the H-1B visa program. So, how has the Trump administration done this? Through a process known as requests for evidence, or RFEs. In a nutshell, once you filed your visa application, it is possible that USCIS could look through that application and decide that it needs more support or more documentation. To ask for more support or clarification, USCIS sends a letter requesting more evidence, a request for evidence, or an RFE. If you don't respond to the RFE, or if the response is late, or if USCIS doesn't think your response is good enough, your application can be denied. So, around 2017, USCIS decided that it was going to change its policy, particularly with respect to computer programmers. It reasoned that a computer programmer did not necessarily require a bachelor's degree, so it was going to require more information on that position before it decided that it qualified as a specialty worker. And it issued an internal policy memo telling USCIS personnel who adjudicate or make a decision on the H-1B applications that it was rescinding an old policy memo from 2000 on this topic. Well, the American Immigration Lawyers Association, or AILA, wanted more information on how this was going to be implemented, so they filed a request for documents pursuant to the Freedom of Information Act, or FOIA. That is the law that guarantees that the U.S. government remains transparent and reveals to the public how it operates. Well, USCIS did not respond to AILA's FOIA request, and AILA filed a lawsuit. To make a long story short, it was through the litigation process that AILA obtained more documents on the H-1B process and learned that in 2017 and 2018, the Trump administration was instructing adjudicators to make more requests for evidence, even if unwarranted, and to make more denials without legal justification for doing so. The result was staggering. Between 2015 and 2019, the H-1B denial rate grew from 6% to 32%, and the percentage of applications receiving RFEs grew 60%. This is significant when you consider why businesses hire a lawyer. They want stability. They want to know that their investments in time and resources will be fruitful. The Trump administration has continued to publish new rules to make it harder for a job to qualify as a specialty occupation and to require employers to pay even higher wages. But the goal is very clear. USCIS wants to limit the influx of foreign workers, especially in the tech field, where the worker is motivated to come to the United States permanently and eventually become a voting citizen. Because the Republicans know, as more foreigners come to work and live in the United States in the tech industry, the faster the white population will lose its majority status, and the faster the Republicans will be out of power. But this is an area where the Biden administration can have some of the most effective actions. Some of the actions will require rescinding regulations, and that process could take several months. But where the Biden administration can be most effective is in changing the culture of the adjudicators. They could be clearer on what will qualify as a specialty occupation, place less emphasis on RFEs, and stop denying applications with no apparent deficiencies. These are actions that the Biden administration can accomplish as soon as Biden's Homeland Security officials are in place. Hopefully, once he is in office, we will see a loosening of the outrageous restrictions that the Trump administration has put in front of the H-1B application process. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.